Dan Ozer here. I'm chatting today with Robert Moore, an attorney with Moore IP Solutions, a firm that advises clients on IP strategy and patent monetization. In addition to working on the legal side, Robert has actively participated in the patent marketplace and monetized a number of portfolios. Before law school, he was a software engineer and a stand-up comic. We'll be discussing a range of topics from the European Union's new IP regulations to various lawsuits and patent pools that seem to be moving us towards codec-related content royalties. Thanks for joining me, Robert.
Pleasure to be here.
So we spoke about the Avanci pool maybe last October, November. What do we know in terms of licensees that they've picked up since then?
I'm not aware of any public announcements of licensees or even scuttlebutt of licensees. So it's possible they have not yet converted any implementers to licensees, although I certainly can't say that definitively. It does. That's not really that surprising, considering that what they're trying to do here is really license a vertical that had previously not paid anything for patent royalties for codecs, the content side. So that involves, on the one hand, a lot of companies that have traditionally only paid based on their unit sales, and they also have some exposure on the content side. And on the other hand, some content providers that have not paid anything traditionally. So there's some inertia to get over with them on the issue of payment at all. They may not even have the legal facilities in place to assess the merits of what Avanci's arguing. So, long story short, I'm not aware of any licensees. They may not have any. That's unsurprising. This is always going to be a long-term play because they have to spend a lot of time educating a new market.
Okay, and there, I looked at the Avanci website over the last few days. Most of the pools that are established have licensees listed, and there are no licensees listed for this pool. So I don't know if they don't have any or they just haven't gotten around to it. The other thing they don't list is the price of the license, and they do list that in a lot of the other pools. Have you heard anything about pricing on that pool?
I don't think I heard anything definitive. I heard some scuttlebutt, but I don't think it's public.
So I think we're going to come back to that after we discuss content royalties in general from a lawsuit perspective and the response from other patent pools. So let's move on. The next thing I wanted to discuss is the Broadcom versus Netflix suit in Germany. Could you just do a quick summary of what that is and where it is right now?
Sure. So Broadcom, as part of a multi-jurisdiction enforcement program, sued Netflix in Germany, and it last year obtained an injunction preventing Netflix from offering HEVC compliant bit streams in that country. The lawsuit, the court in that lawsuit found that that Broadcom's patents, which were directed to an HEVC encoded bit stream, were infringed and valid. So that's an interesting facet of this case because most of the litigated claims to date for video codecs have been directed to devices and not bit streams. So if bit streams are a viable mechanism for enforcement, and as this court found, it doesn't really matter where the bit stream originated or where its ultimate destination is, so long as there's a bit stream that's active within a given geography, then there is an act of infringement. That's something that could be potentially inform considerable liability in the future.
Okay, a couple of things to unpack there. Number one, you talked about bitstream patents. How would you differentiate that from patents related to decoder, encoder, whatever?
First off, there's just on their face, most of these claims, most of the essential claims are going to define themselves as directed to an encoder, decoder, or bitstream. The actual standard defines a bit stream. So the actual infringing article has, to date, for the most part, been a decoder that resides on a device, in an app, or something like that. But now, if you can obtain a patent, an enforceable patent on a bit stream, and you don't necessarily have to worry about some of the considerations for enforcing, like I mentioned, where the bit stream originated or where it's going, then that's a bit different than what we have seen in previous codec litigation.
I guess my question is, do we know if the patents that Broadcom was attempting to enforce were bitstream specific as opposed to decoder specific?
Yeah, I'm not sure. I haven't seen an English translation of the complaint, but for the most part, bitstream claims are going to say bitstream right in the preamble to the claim.
Netflix has been charged $7 million so far, but that's all relating to the fact that they've refused to stop publishing, right? That's not actual damages, that's more punishment. So do we know anything about what Broadcom is claiming for compensation for use of the patents in the content?
I've not seen that public, but again, I think this is just one aspect of a worldwide monetization program. So whatever Broadcom's looking for is probably going to include Netflix's exposure in other countries, including the US, where they also have cases pending.
From a precedent standpoint, what does this mean for cases in the United States for content?
Well, it's probably right now easier to bring a content case in the EU if bitstream claims are viable for the reasons I mentioned than in the United States. So what follows from that is that if the EU is going to be a preferred venue for enforcement, then the EU is going, and German courts in particular, are going to be able to have a more defined body of case law, judges with subject matter expertise, and so on, and that will beget additional litigation along the same lines, and the German courts will be able to sculpt the metes and bounds of content side video codec patent litigation in a way that reflects the German approach to balancing the needs of implementers and SCP holders.
Can they set a worldwide rate and enforce that payment from Netflix to Broadcom?
I'm not sure if German courts would do that. We have seen other courts in other SCP matters say that a company, an implementer, has to pay a worldwide rate, or else they will be subject to an injunction in that country. So at that point, we've seen the UK has done this, for instance, and we've seen certain companies just say, "Well, okay, we're just not going to do business in the UK. We're not going to go and pay a worldwide rate, or at least not a worldwide rate on the terms that you're computing." So it's really the ability of the German court to go and enforce this is a matter of number one, German law, which I'm not sure the status of there, but number two, whether the given jurisdiction that's trying to go and set a worldwide rate has the juice to compel these licensees to pay what they say they got to pay, or else face an injunction.
What constitutes juice from that perspective?
Is it an important enough jurisdiction for that company's overall business, so that if they were not able to do the thing they're enjoined from doing, it would be material, right? So Germany's a huge country, huge economy, probably pretty important. But for companies like Oppo, cell phone company, a Chinese cell phone company, the UK was not important enough for their business to the point where they felt like it. They would rather pay what the UK court said they should pay worldwide instead of just exiting the market altogether.
Okay, so let's assume Germany sets a worldwide rate for Netflix. Netflix pays that. Can Broadcom sue Netflix in the United States for more? Or, I mean, how does that work from stopping additional lawsuits on the same subject matter around the world?
Well, ultimately, the injunction is going to be for Germany, and what they're going to say is until you get a license, Netflix, you are enjoined. You cannot go and have HEVC compliant bit streams in Germany. So they can say that what Broadcom is allowed to do in seeking a license is drive a worldwide outcome. If there's case law in the United States that suggests that that's an inappropriate outcome, that at least under certain jurisdictions, United States interpretations of United States law and policy, that each country should set its own, and that would require enforcement country by country potentially, which is something that we've actually seen quite a bit of. So ultimately, whether this results in a worldwide license is going to be up to the metes and bounds of the German injunction, which I'm not privy to, and to the extent that it allows Broadcom to demand a worldwide license, whether Broadcom chooses to pursue that or to just settle liability in a given jurisdiction one at a time.
So that's Broadcom versus Netflix in Germany. What do we know about Nokia versus Amazon and HP here in the States?
Well, towards the end of last year, Nokia brought a lawsuit against those companies on a number of patents that Nokia said were essential to H.264 and 265. In the Amazon complaint, for instance, they were targeting Prime Video, Amazon.com, Twitch, and so on. So it seems to be going after the services. If you look at the actual asserted patents, at least some of them are directed to encoders. The standard itself is directed to decoder, or I should say directed to bitstream, which means that the infringing article under to date, under most interpretations, has been the decoder. And what that means, taking another step, is that the patents that Nokia is advancing, at least arguably, would not be subject to FRAND. That's the encumbrance that comes from participating in a standard setting process, and that imparts certain requirements on the negotiation and sometimes the license that an SEP owner has to offer an implementer of the standard they worked on.
So that's fair, reasonable, and non-discriminatory.
Yeah, that's right.
FRAND.
So
what? I don't get that. I mean, it's. Are you saying it's part of the standard, not part of the standard?
What probably happened here is that Nokia participated in standard setting. They developed a lot of technology that they contributed to the standard. Some of that technology is protected by patents that are directed to the bitstream or decoder, and those would be standard essential. Some would not be. Some would be directed to the encoder side. If that's the case, then you would not be able to, I would say, conventional approaches to patent litigation read claims of the encoder side patents directly onto the specification for the standard. And instead, you would have to rely on some alternative theories, including indirect infringement or something like that. If that's the case, then there isn't going to be this requirement that Nokia negotiate with Amazon on consistent with the obligations of FRAND. So that includes, I always call it an affirmative obligation of good faith dealing, where you have to really show your math in the course of negotiating. You have to say, here's what my rate is, and here's how I arrive at it. And then you have to listen to the other side. You have to give them time, then you have to listen to the other side. Not the case necessarily with non-standard essential patents, where you can just sue if you want to.
Okay. And the answer has not been filed yet. Is there any defenses asserted yet that you know of?
Yeah, there was a motion.
Any motions filed?
Yeah, there's a motion to dismiss that was filed, and it raises patent validity as a defense. It's not surprising that the motion to dismiss doesn't raise policy arguments as well. Those could be reserved, and it could be the case that they're simply not applicable. Like if there's a FRAND defense, maybe it's not applicable in this case because these are not standard essential patents. I'm not sure. This is an evolving area of law, so it's possible that that what constitutes a standard essential patent, or our understanding of it, could change over time, possibly through cases like this.
Okay. What are the public policy arguments you see as potentially being relevant?
It's the usual ones,
if any.
Yeah, it's the usual ones that you see for standard essential patents. Most of them kind of come down to from an implementer side. They come down to the premise that when you have standard essential patents, you have basically there's such an incentive for implementers to implement a popular standard like H.264 that there's that the patent owners can obtain an unfair premium because there's no way to design around it. And so there's public policy arguments that manifest in different ways that just sort of say there should be some way to prevent a windfall from prevent the SCP owners from obtaining a windfall just because their patents were included in the standard.
I mean, that's what gives rise to the brand. What are the public policy arguments you see against content royalties specifically?
Well, I think the major one is that we haven't done it that much. So you have a market that has come to expect that the patent royalties will be paid at one part of the value chain, the devices. And if you are to introduce liability elsewhere in the value chain, then the whole value chain potentially might have to adjust. So there's that.
Okay. Do you think that would be particularly compelling, or more pro forma argument that probably will get dismissed?
I don't see that as much of a legal argument. I see that as an argument that a lot of companies, implementers would make to regulatory bodies, as well as just generally to curry favor with the public. I'm not sure how successful it'll be. It's hard to say. It's hard to argue with the fact that we have a licensing paradigm that was decided 20, 30 years ago before there was streaming. And now you have a lot of the value of streaming inuring to the benefit of the content side in a way that it wasn't really before, right? So, YouTube, Netflix, these are huge companies. And to say that they don't independently derive benefit from all the video codecs that they implement, that doesn't make sense to a lot of people. And they think that they should probably contribute the same way that every device manufacturer is expected to contribute to these overall patent royalties.
Yeah, that kind of ignores the reality that H.264 considered a royalty on free internet content, ultimately decided not to do it, largely because of WebM, and that HEBC Advanced, when they came out with their first license, that had a 0.5% content fee as well, and they withdrew that because of the Alliance for Open Media, or the seemingly, as the events flowed, that was potentially the reason. So They did propose content royalties, then they withdrew them. So I mean, is there an estoppel argument that says that you suck these people into the standard, you made the standard pervasive, and now you're going to charge content royalties? Is it?
So the estoppel argument would be, I, as a content provider, relied on your representations that you would not charge a royalty, and then because of that, and went ahead and implemented the standard. Now you are asking for a royalty, and you shouldn't be able to. That's the estoppel argument. There's a lot of challenges to that. First off, it would, to the extent that it would apply at all, it would be to members of. It would only be to licensors that either themselves made that representation or had authorized a third party like the Access Advanced pool to make a representation to that effect. So if it's a Nokia, which is not a member of a patent pool, then it would be hard to go and pin that representation on them. But then you also get into the question of what exactly was the representation that was made by the patent pool. And you're absolutely correct. There was an effort by Access Advance when it started to try to license content royalties, and there was a negative reaction in the market, and Access Advance backed off of that. But what did they actually say? Did they say there would never be royalties that were charged for content? I think, they have at times, I'm not sure this is still available, they have at times offered covenants not to sue to implementers on the content side. And if that's the case, then those content side guys should have taken those, right? I'm not sure that it's Access's fault that that these content side guys elected not to take them up on their offer.
It's interesting because I think MPEG-LA actually did want content publishers to sign a license agreement, even if there wasn't going to be a royalty. I think I remember them pursuing that, and I'll have to go back and see if that included a covenant not to charge. I remember talking to Mattia Fogliaccio. I just sort of mangled his name, but from Sisvel when the VP9 and AB1 pools came out, and he was very careful in saying, we're not charging for content now, but if the patent owners decide to charge for content later, they can. And that struck with me because it let me know that the content owner, that the patent owners were in charge, which really wasn't is obvious, but wasn't forefront in my mind. But also that hey, it could always happen down the road. So I think Sisvel has been very clear on that. This kind of gets us to an interesting point. We've got the Avanci pool charging content royalties. We've got Broadcom versus Netflix saying you can charge for these in Germany, and we've got the Nokia versus Amazon lawsuit that if Nokia wins, is going to make content royalties effective in the United States. And then you've got a bunch of patent owners in other pools, whether it's Access Advance, VLA, or Sisvel, that aren't in the Avanci pool. And what's to stop them? I mean, I guess their choice is either we join Avanci or we convince our patent pool administrators to create a separate pool for content royalties or to start charging within that pool. And I know that certainly this is something that VLA said that they were considering. What do you think is going to happen respecting the other, Access Advance and Sisvel, respecting content royalties going forward?
Well, that is tough to predict. Obviously, as you said, there seems to be some momentum towards among the SEP holders towards licensing content side. They may elect to do so bilaterally. They may just approach the major implementers on the content side and try to strike a deal outside of the patent pools. They may try to drive their patent pools towards having licensing content themselves. I guess I don't have any special insight here. I think we'll probably know more, and probably by the end of the year, about the direction that these other patent pools are going.
Well, don't these companies have a responsibility to monetize their IP as broadly as possible? I mean, they're public companies for the most part, or many of them. I mean, the small business guys that aren't operators, I don't know what they have absolutely no reason not to want to monetize. And you could look at some of the other companies, whether it's a content publisher like Netflix, which I think is part of at least one patent pool, and you could say they may not want to do it. But if you're a smaller company, I don't know why you wouldn't. And either it's going to be within the pool you're in, or you're going to join Avanci. I mean, I'm sorry, I'm beating you about that argument, and you've already kind of asked and answered, I guess I would say. But any further thoughts on that?
Not really. I mean, I think we're going to have.
Okay.
Yeah, I think we can just leave it at that.
Okay. Okay. One of the big deals that happened that I think relate to codec royalties in particular, not content royalties, is the Sisvel and RPX agreement that happened back in December of 2023. Describe what happened there and what you think the significance is.
So Sisvel in I don't remember the exact year, maybe 2018 thereabouts, 2019.
2018.
They went to market with a patent pool that was directed to the VP9 and AV1 codecs. These were codecs that were created by Google and or the Alliance for Open Media and were positioned as quote-unquote royalty-free. And Sisvel said that there is some royalty that is attached to these. The patent owners that were part of that pool were, I think they were mostly also part of the Access Advanced HEVC pool, and the patents that they were putting into this, the VP9 AV1 pool, were patents that were also in other patent pools for AVC and HEVC. So these are patents that were created, that reflected development on other codecs, AVC and HEVC in particular. So over time, Sisvel tries to license the overall AV1 VP9 ecosystem the same way that MPEG-LA successfully licensed the VP8 ecosystem back in 2012 or so. And it culminated in this deal at the end of last year. So RPX, I think it might be helpful to just give a bit of a primer on what RPX is. All right, so RPX has a business model that's probably not well understood outside of patent monetization circles. They are what's called a defensive patent aggregator. They're an intermediary in the market that works with, on the one hand, their own subscribers, which are the companies that implement patented technology, not only SCPs, and on the other hand, those that are creating the risk, the patent risk, to clear that risk. So the RPX, they get money from subscriber fees. These are all the companies that want to have the option of taking a deal that RPX puts on the table. And they also probably make some money in the course of actually doing some deals. They will negotiate with a patent owner that has a certain amount of risk about what the settlement values would be for the given constituent parties to a deal. They're subscribers that are going to take an option to get a license. And the effect of this is that it, in some cases, is a more efficient way to license an ecosystem. Like especially when there's a value chain or a supply chain where liability can be up and down the supply chain, you may not want to go and deal directly with the farthest upstream liable party, because if you do that, then you might be leaving some, as a patent owner, you might be leaving some of the liability on the table. But at the same time, in order to go and get even like the smaller players those are probably inefficient to license. It's hard to sue the small guys and make any money at it. So it makes sense to have a global resolution that encompasses upstream and downstream in some cases. So that could be what's happened here. Like this deal, it included, I think the public statement was that it affected 16 tech companies. That were granted a license to this pool, the patents in the AV1 pool at least. And I don't think it's public what companies those are. I don't have any special insight into what companies those are, but it wouldn't surprise me if this was analogous to the deal that Google struck with MPEG LA in 2012 to clear risk for the VP8 ecosystem. You have the Sisvel patent pool, which offers a license based on unit sales of devices. And then you have Google, again, without any special knowledge, but I'm speculating here. Google potentially stepping in and saying that we want this codec to be that we worked on to be more widely available, including on devices that implement our operating system, that have our browser on them, that support our streaming apps and so on. And we're willing to go and at least pay, pay a portion of the overall liability that exceeds what they would pay on a per device basis. Like, they're not just paying under what I'm speculating. They would not just be paying for the number of Chromebooks that they sell. They would be paying generally a disproportionate share of the overall liability that Sisvel is looking to collect on. That's why it's helpful to have this third party intermediary, RPX, step in to go and act almost like a mediator and talk to both sides about the respective merits, respective liability, and try to come up with a way that a proposal that reflects the value Sisvel sees and wants to realize from the overall feature of compliance with the standard, and also is something that allows the AV1 ecosystem, the value chain there, to allocate risk in a way that they find palatable. There are some, and the other byproduct of this might be, because it's an efficient outcome, sometimes the actual amounts that are paid are less than they would be paid if you went target by target as an enforcer. That suggests to me, all of that together suggests to me that the royalties here were probably not over in the aggregate what Sisvel advertised as the rates that it was looking to realize, which is 32 euro cents per consumer display device for AV1.
But way down in volume. I mean, it really comes down.
Yeah, right.
So the Sisvel pool charges royalties on decoders. So what impact would this have on publishers? I mean, if I'm, ESPN or I'm CNN, I don't sell a decoder. Does the RPX, and maybe 2 years ago, you looked at AV1 and said, it's royalty free. I'm going to trust the Alliance for Open Media. Does this deal give AV1 and the Sisvel pools more credibility than it otherwise had? And I guess the ancillary question is, does the fact that AV1 is represented in the Avanci pool from a content perspective, does this throw kind of a double scare into content publishers who are considering AV1 and 2 years ago thinking it was going to be royalty free, but does this present kind of a new paradigm for them?
So that's a good question. I think the Sisvel deal simultaneously clears a lot of risk for the AV1, the feature of compliance with AV1, and at the same time admits that there was risk in the first place. It puts the lie to the statement that it's royalty free. I note that there were at least one licensor, one previous member of Sisvel's AV1 pool that elected not to move forward with this deal, InterDigital, and they're a well-known and well-regarded company in patent monetization, highly innovative company that is probably going to try to license its targets outside of the pool now. So that could scare some content providers just based on that. Other than that, I'm not sure exactly what the parameters of the RPX deal are. I'm not sure who what 16 tech companies took a license to it. I'm not sure if the deal was limited in field of use to devices, notwithstanding what the actual public statements of the Sisvel pool are. It could be that it's a global resolution where anyone who implements the Android operating system gets a license, just to pick one possibility.
Without knowing any inside information about who's,
I truly do not
both
know
RPX and Sisvel have been very okay. I guess the Alliance for Open Media came out in 2015. The Bitstream shipped in 2018. The Sisvel pool was either 18 or 19. Why haven't we seen any litigation yet on that? And what does it mean that we haven't?
Well, first off, I think the AV1's implementation has been slower to roll out than a lot of people expected, and the installed base just wasn't there to support a monetization program. That's one. Two, there has been, I believe, pretty aggressive licensing behind the scenes bilaterally, to the extent that there are companies that will be logical targets. They have sought out some, maybe through Sisvel, but possibly through just one-on-one conversations, the patent rights that they think they need, right? So I'll just give you an ancillary example here. Apple implements HEVC on all iPhones, and they have not had, to my knowledge, material HEVC litigation against them, even though they're not part of the Access Advanced pool, which covers the lion's share of HEVC SEPs. The only reason for that I can think of is that Apple has affirmatively sought out the patent rights that it needs. The people that it expects would want to sue them on that feature, it has gotten a license. I expect you're probably seeing the same thing behind the scenes for AV1.
Okay. And that takes us to the EU regulations. So can you summarize, I guess at a high level, what happened with the EU and their new, I don't even want to call them proposed, I think they've been voted on, and now it's just the final regulation that's waiting to happen. Can you kind of summarize where that is?
Oh man, I'm probably going to get some of the procedure wrong here. I'll just say this: the European Commission has attempted to come up with guidelines for licensing standard essential patents. These guidelines include things like a prescribed royalty rate, aggregate royalty rate, for the feature of compliance with a given standard, and mechanisms for determining, for cataloging and determining the corpus of standard essential patents. So if you have a standard essential patent under these rules, you would go and submit it to the EU Commission, the designated body, and they would review it and determine whether or not it's essential in their book, and then it would that would feed into the amount of royalties that you would be able to charge in member countries. There have been a lot of objections to this. I can't even begin to articulate all of them. I'll just pick one. The royalty stack as the basis for the royalties that any given party may be entitled to. You see this argument a lot in standard essential patent litigation, that company X, SEP holder X, is seeking $1 per unit, but they only have 10% of all the SEPs. If you go and you do the math, then that means that we'd be paying $10 for the feature of standard compliance, and our margins don't support that. That argument happens a lot. But there's a lot of SEPs that just go unlicensed, right? They're expired. They belong to companies that have business reasons or lack the money to advance their own patent monetization or so on. So the actual universe of patents of SEPs that companies have to pay on is much lower than the universe of actually essential patents. So this has always been a reason, an objection to the royalty stack approach, which we've seen really in most court adjudications of what a FRAND rate would be for a given portfolio of standard essential patents. They start off with the idea of what the feature, what people pay for the feature of compliance with the standard is. And they always run into this issue. The other issue they run into is a geographic one, where you have the amount that you pay in one country may not be market in another country. Like we've seen, you can see it with the Access Advance rates. Access Advance charges less in China than it does in the United States for patent royalties because the margins on devices in China are lower. It's hard to go and say definitively what the royalty stack is without the context of what the margins are for that country. And that's not something that...
When you say royalty stack, you mean the aggregate royalty, the figuring out what the total cost is and then allocating that. And it really, the other argument against that is that not all, if you do it strictly numerically, not all patents are worth the same. Some are very, very essential to the standard and probably deserve more than those that it might be ancillary or may cover just a small, tiny bit of the standard. So a lot of issues with that. I mean, as much as I could see any implementer wanting to know what the price is before they get into it, it just seems that no court has been able to determine that. And I guess that, a couple of objections that I've seen, and I'm, we're having this conversation. I'm doing this after doing research for an article that I'm writing for Streaming Media Magazine. But, the number one objection has been, this is solution in search of a problem. The courts are working fine. And there's a good balance between the implementers and the patent owners in terms of who's paying what and how much they're getting. So that's number one. Number two is, you're creating this new body that's got no expertise, or you're utilizing an existing body in a different way in which they have no expertise, and it's really going to jam up the courts. And then kind of getting to a point that you mentioned a few minutes ago, what do you see this doing to Europe as a place where patent owners may try and enforce their patents as opposed to other jurisdictions?
Well, I think countries and jurisdictions that want to have a say in how to balance the benefits of standard implementation between implementers and SEP holders should want to attract SEP litigation, and that means being seen as a venue that's at least fair, if not favorable, to SEP holders. Someone's going to set the rules. Someone is going to say that the way that you compute a FRAND rate is X, Y, and Z. And X, Y, and Z can be adjusted to favor low margin products or to favor knowledge economies. If you're one of those two, you have an incentive to go in and slice the apple in a different way. And you should probably, as a matter of policy, want to have a say on that. That means going and attracting SEP litigation. I think this EU Commission is going to deter the EU as a venue if it moves forward. And if that's the case, the EU will have less of a say over how its SEP owners are compensated, incentivizing participation in standard setting, to the detriment of standards and to the detriment of companies that want to implement those standards. And also the implementer side, whether they get good standards to to be whether the standards that they are going to implement are any good, and also whether and how much they end up paying, including even what part of the value chain they ends up paying the bulk of the royalties. Can we just hone in on one thing? I want to make one more point here, because I think it's a good thing you raised. A solution in search of a problem. We actually don't have a lot of SCP disputes, public SCP disputes, relative to how pervasive standards are. This is not a point that's often made. Look at the iPhone. An iPhone has the cellular standards on it, 4G, 5G at least. It has Bluetooth. It has Wi-Fi. It has codecs 264, 265. It has AAC audio. It has LPDIMM memory, and so on. It has a lot of standards on it. Just for the cellular standards alone, over 100 companies have declared essential patents for 5G. I would estimate there's some overlap amongst these standards amongst the companies that are SCP owners, but I would estimate there's over 250 companies that have that own patents that they consider to be essential to standards that Apple implements. And yet, Apple is not sued 250 times a year on SCPs. They're sued a handful of times. That, to me, is evidence of the market mainly working. The big targets are able to clear the risk in a way that they find palatable. It doesn't result in litigation for the most part. And the smaller targets are just not targeted because it's inefficient to do so.
Okay. I guess one of the concerns about the EU regulations is that they may spill over to other jurisdictions, including the United States. I mean, what's been the legislative effort here in the States to create similar regulations or laws?
I don't think there have been a lot. I don't think there's a lot of momentum behind a similar proposal in the EU. There's a lot of times when Americans look at things, legal developments in the EU, and say we should bring that over here. The way that the EU handles antitrust, for instance, competition law over there, is considerably different and more exacting than it is over here. But I don't see a lot of efforts to go and update I don't see a lot of successful efforts to update our laws to go and bring them into broad alignment with the EU's. I think that's probably true here of standard essential patents. I don't think that a lot of people would support the effort to create a registry of patents, of standard essential patents, and then some sort of mechanism for determining the value of those patents. It's a lot of oversight, a lot of due process that would need to get processed, and it seems like it would be pretty tough to administer. So I don't see it happening.
Okay. Anything else you want to talk about? This has been pretty comprehensive, and I think we covered everything that I have. Any other issues that you think people, and again, this is targeted primarily towards publishers who are concerned about the IP issues they need to be thinking about over the next few years. Any other issues they need to be thinking about?
I don't think it would hurt any content provider that's concerned to just talk to the patent pools and see what their plans are. They're as equipped as anyone to do it. And at the very least, they should have a sense from those conversations about, if not the timetable for a decision on whether the patent pools will pursue content, an update on how likely it could be. It may be ruled out altogether. I don't know. But whatever they say, I think could help inform the decisions by these content providers to implement any given codec. Okay.
One final question. Any sense of the respective value of content versus player? I've heard some people talk about the fact that the the bitstream claims may be less powerful for some reason than the decoder claims, and for that reason, we know that Access Advance has, say, a $45 million annual cap. Do we, will content be a small fraction of that? Will it be equal to that? Will it be more than that? Do you have any sense of where that may fall out for a particular publisher?
Yeah, it's hard to say at this point. I think the metrics that will be used for the for content side are going to be radically different than per unit. Obviously, you're not just going to charge YouTube every time a YouTube app is instantiated. You'd probably charge them on the basis of things like their revenue or their monthly active users or something like that. And if that's the case, it's hard to have an apples-to-apples comparison. Aside from saying YouTube is an enterprise with a valuation or with revenues of X relative to, and then find a company that has comparable revenues on the device side. If you compare those to each other, I'm actually not sure in the end who will end up paying more if we do move forward with this paradigm where content side pays more. So very early to say who's gonna end up paying more. I will just say also as I have always understood the patent pool's approach to licensing the codecs, the effort to license at the device level, to focus on that, was informed by the fact that the devices were able to go and allocate the risk themselves amongst the value chain to some extent. You have a lot of companies there's a lot of revenue that's exchanging hands up and down the value chain based on things like subscribers. For instance, if you have, subscriber content side subscriber service X, and it gets and someone signs up for a subscription on your Apple device, there's probably going to be some payment from the content side to the device, and that those payments partially at least offset the payments that Apple as a device side is going to have to make to cover the feature of compliance with the video codec standards.
All right, listen, I really appreciate the time you were able to spend. It was great for me and hopefully great for a lot of the people who will be watching this, and we'll talk to you soon.
Sure. Take care, Jim.